Yeah.
Like we normally do, when we get when it's the time to somebody speak, please raise your hand and state your name, your address, so it can be put in the minutes of the meeting. When it comes to the second application of Nipissing Street, third application of Dover Court, please, the meeting was sent back to the planning meeting here. So anything new that wasn't able to be said during the last meeting, you now have your chance to do it, okay? But in an orderly fashion. Okay, so on that name, we're going ahead with the agenda.
Sorry. Declaration.
The declaration of pecuniary interest. Is there any? Do you have for?
I have for pecuniary interest on the zoning bylaw amendment application of 5.2.
Okay, just the second one. And I have the third one for Dover Court. And I will recuse myself during that application. Okay, so that we move to the agenda, please.
Yes. It is moved by Kathleen Rashaw and seconded by Roland Larrabee. Be it resolved that the agenda for the Planning Advisory Committee meeting held on May 13th, 2025 be adopted as presented.
Everything's okay? We'll call it to a vote. Everybody okay?
Sorry, one thing. Are the minutes actually in the electronic agenda? Because they're not printed here.
My apologies. No, they are not.
So,
Not. So what we can do then is at the next Planning Advisory Committee meeting, we can adopt the previous agendas and tonight's minutes. My apologies. I'll make a note of that.
All right.
I thought I saw them somewhere else, but
I thought they were somewhere too. Interesting. Okay. Sorry. My apologies.
Okay, so no minutes. We'll go to the zoning bylaw 5.1. ZBLA 2025-05, Gaétan Labelle and Carole.
It is moved by Roland Larrabee and seconded by Kathleen Shaw, whereas a public meeting was held on May 13th, 2025 for the purpose of amending zoning bylaw 2014-45, and whereas no written concerns or objections have been received to the proposed amendment, be it resolved that the Planning Advisory Committee of the Municipality of West Nipissing recommends that Council for the West Nipissing Municipality adopts the proposed zoning bylaw to rezone a property at 592 Rainville Road, and more particularly shown on the attached sketch, and that Schedule G3-4 of Bylaw 2014-45 shall be amended by changing the zoning designation of the property, which property is more particularly described as part of Lot 5, Concession B, Parts 1 and 2, 36R 3552, Part 2, 36R 14262, Caldwell Township, Municipality of West Nipissing, from rural residential to and agricultural 1 to agricultural 1, exception zone 1, to allow for an accessory dwelling unit. Through you, Mr. Chair, I'm just going to share my screen here quickly. This application is proposed for 592 Rainville Road. The applicants are looking to do a detached additional dwelling unit on the property. The property currently is split zoned because the portion that's kind of shorter was a lot addition previously. So that retained the A1 zone from the lot it was added from. And the portion that has the house on it currently is rural residential. So in order to tidy up the split zoning, the entire property is going to that special zone to allow that unit. This was brought to the Agricultural Advisory Committee on April 2nd, and they had no concerns with it.
Okay. Thank you. Anything from the board members?
I have no issue with it.
Go ahead, Kathleen.
If the property, if the lot addition hadn't been done and it was a standalone lot, would they be able to build a structure on it?
Sorry, the residential part or the part that was added to it?
The part that they're proposing to build on was the lot addition, and that was zoned as A1 at the time that it was added?
Correct.
And A1 would not have allowed for them to build a structure.
A1 allows for a dwelling.
It does, it's A2.
A2 that doesn't allow for it. Yeah.
Thank you.
Okay, anything else from the board? Ruck, all good? Okay, anything from the public on this matter? No? All right. Hearing none, I'll bring it to a vote. Anybody in favor? Carried.
Thank you.
Okay, so we'll move to 5.2, ZBLA 2024-13, Charles Couture and Jeanette Lachance.
Thank you.
Sorry,
Sure, go
and
ahead.
I do have to, anything new on this matter? We're not going to redo all the same procedures on what we've heard before. So anything new, that's why it was brought back to this meeting, so we can hear anything new on this matter. Go ahead.
Thank you. It is moved by Dan Seguin and seconded by Dan Gagne, whereas a public meeting was held on April 8th, 2025 and May 13th, 2025 for the purpose of amending zoning bylaw 2014-45, and whereas written concerns or objections have been received to the proposed amendment and were provided to the Planning Advisory Committee for consideration, be it resolved that the Planning Advisory Committee for the West Nipissing Municipality recommends that Council for the West Nipissing Municipality adopts the proposed zoning bylaw to rezone a property at 734 Nipissing Street, more particularly shown on the attached sketch, and that Schedule 8.5-1 of Bylaw 2014-45 shall be amended by changing the zoning designation of the property shown on Schedule A attached, which properties are more particularly described as part of Lot 3, Concession B, Part 1, 36R 15253, Springer Township, Municipality of West Nipissing, from rural residential to rural residential exception zone 5. Through Mr. Chair, I'll pull it up here quickly for us. So this application, as you said earlier, has been brought before the committee previously. The application is to increase the permitted gross floor area of a home industry and to permit 2 detached additional units. The application that was most recently heard also requested a increase in the permitted height. It since has been amended by the applicant to reduce it below the height requirement So that variance is no longer required with the newly proposed amendment, and you do have the elevations for that that were provided.
So that's something new that just came up, that the height, maximum height has been reduced.
Yes, that is correct. Yeah.
Any questions from our panel? No? Okay, so I'll bring it out to the floor. Anybody that has anything new to add to this planning meeting, go ahead. Paul?
Oh, thank you very much, Mr. Chair. In addition to what Samantha said about the increased height, I do have, we've had to go real old school. So we've got these on paper just to bring them forward. These ones don't apply. So what was up on screen showed one of the original proposals. I believe it was hard for me to see from back there, but it showed a revision 4 to the original proposal. It showed the parking basically at the back and at the side of the karate club structure, or the karate studio structure. And so we've worked, listening to the neighbors' concerns, we've worked with the client and the current site plan. One of the changes that we've made is we brought all of the parking to the rear of the karate studio so it would not be visible from the neighbors from the street. And you'll also notice the distance back from the street line that the karate studio is, and the house and the garage are set even further back on the property. And that was specifically to be able to separate the personal use on the property from the karate studio. The height, as mentioned, has been reduced, and we've been able to achieve compliance with the bylaw. In fact, we're now underneath what the maximum requirement is. We're able to do that. Initially, the studio was 13 feet in height. The minimum required by Charles for the operation that they have is 12 feet. We're able to reduce the height of the ceiling to 12 feet. And also we reduced the pitch of the roof from a 412 pitch to a 212 pitch. And by doing so, basically, if you have a copy of this sketch at all in your package, the upper of the two dark lines is the maximum. The lower of the two dark lines is now where we show compliance with the bylaw. One of the things that really has to be understood about this site to appreciate the use that's being proposed relative to the community that surrounds it is the size of the lot. And I believe, and I'm sorry, I should be showing these to the public as well. So what this image clearly shows is the relative sizes of the lots along Nipissing Street and as well along the lakefront. This lot is easily 2.5 times the size of any of the existing lots in the neighborhood. So but you'll also see, and we'll make it a little more clear with the next image. Well, this is just a blow up of that same area. And on this same area, I've put in the current site plan. But like I've stated, we've moved the parking from the side of the structure here where it was visible to the street to in behind. But you can see the size of the structures that we're talking about. So when we talk about, because the size of the structure was a big concern last time. So we've shown the size of the structure. The dashed line on here is the structure that would be fully compliant with the zoning bylaw at 1,500 square feet, approximately 140 square meters. You can see the houses in the neighborhood. They're beautiful homes. They're nice big homes. This home in particular is well in excess of either the home Charles and Jeanette are planning to construct on the site, as well as the studio itself. Even some of the accessory structures, the garages that are built on these existing lots also are of similar size to what we're proposing on this particular lot. This is all to scale. We've put everything into scale according to what the satellite imagery shows. And you can see how, because of the smaller lots, how tightly compressed the development is on the 1 acre lots compared to the amount of land that we have on the site here, the 2.5 acres with smaller structures, more spread out, and also with a lot of additional room for septic capacity on this lot. And that becomes important a little bit later. That's the site plan with the original. We've already referenced that. This is just that street view. So one of the issues was, well, 1,500 square feet's the minimum. We're looking to go to 2,000. What's the impact going to be on the neighborhood? So if you're standing on the street looking at the property, this is what a 1,500 square foot building looks like. Just like that. When we increase the size to 2,000 square feet, and this is done at the same scale, this is what the building looks like from the street. Now, if I hold these two up, you'll see the point that I'm trying to make, because you're going to say, Paul, what are you doing? Those are both the same drawing. And that's entirely the point. The building is 40 feet wide. The building's going to be 40 feet wide, whether it's 1,500 square feet or whether it's 2,000 square feet. So the impact on the neighborhood of the increased size is basically very, very minimal or zero. If you look at the building from the side, this is the impact as well. So this is a 2,000 square foot building at that footprint. This is the 1,500 square foot. It's a difference of 12.5 feet, basically from here to the end of that table. That's the only difference, set back from the road over 70 feet on a very large lot. Once again, the visual impact to the neighborhood is minimal. So then we get down to the use of the land. The use of the land is a permitted use. They're allowed a home industry occupation on the site as a matter of right, as long as they conform to all of the standards of the bylaw. Other people in this neighborhood have home occupation businesses on their sites, no different. Now, they do comply with all provisions of the bylaw, I don't doubt that. The only thing we're asking for here in terms of the use as a karate studio is by being able to build it to the size that they actually want to, that makes sense for the use that they're making. The noise, it's all interior. It's all inside the structure. So that cuts down on the noise to the neighborhood. And once again, it's set well back off of the street. So really the only thing we're asking for, the use is permitted. There's no issue with respect to the use. The height has been reduced to be below the maximum required by the bylaw. So we're looking at an increase in square footage of approximately 500 square feet, basically the size of a living room and half a dining room on the structure. And we're also asking for 2 accessory dwelling units. Now, the 2 accessory dwelling units, and the reason for this ask is Charles and Jeanette have 2 daughters. One is I've been told it's really bad form to say a woman's age. So I will tell you that one is in her mid to late 20s. The other is approximately early 30s. Both are employed in town, but they're single women. They are having a hard time finding safe, suitable, affordable housing within the municipality. This is something Charles and Jeanette can do for their daughters. They can give them each their own independent apartment on site. In terms of septic load of the additional dwelling units, in this particular instance, if they're not in the apartment units, they're living in the home. They still have the same number of showers. They still use the washroom the same. They still use the kitchen facilities the same, whether they're in the house or in the apartment units. So there really is no additional load on the septic. And we've already talked, remember last meeting as well, one of the big issues of the neighborhood was the wells and the water quality issue, the water quantity issue. So we specifically retained Dr. Sig Kirchhofer, and we specifically asked him to come to the meeting so that if anyone had any concerns, he would be able to address their concerns. Not a single member of the public asked a single question of Sig. Not a single member of the committee asked a single question of Dr. Kirchhofer. So the water issue seems to not be as much of an issue as maybe it was brought out to be. And I'm not denying that it exists. We still plan on hiring SIG to do the hydro-G assessment to prove that this will be compatible with the neighborhood. One of the issues that we've specifically asked SIG to look at is the capacity of this very much larger lot to be able to handle the septic load from the house and the 2 apartment units. So that will be covered off, and it wouldn't be brought back to the council for the final vote until we know what the results of that are. The way we initially proposed this to occur right from day one. So the other big issue that took a lot of airtime too was the staging of development. And Charles at that last meeting has said that he's quite willing to build the house and the studio at exactly the same time. So it's not that we're trying to build an accessory structure without a house. The building permits will be submitted simultaneously. He will build both units simultaneously. The garage may wait till later, but that's secondary. So the one thing I think that we really want to impress upon the committee and the public is, as long as we meet the minimum standards of the bylaw, this application can move forward without any further public input. The only process that we need to go through is a building permit application process. So if Charles and Jeanette decide to reduce the size of the structure to 1,500 square feet, cut it down to just a single accessory dwelling unit where either both daughters live together or one continues to live in the house, one in the apartment, whatever the arrangement is. We've already reduced the height requirement. We meet the bylaw. So if that is the case, this would still occur on this site no matter what. And it is a home occupation industry. It's a home occupation use. And that was in the original planning report. So it's no different than anyone else's use on their land for a home occupation. The 1,500 square foot also, by limiting it in size, typically is to prevent competition with existing businesses. So if somebody wants to do car repairs on, at their house in the evenings, it physically limits the size to which they can grow so that they do not become competition with existing businesses. That's the main reason for limiting the size of the home industry on a residential lot. In this case, we don't have, it's a totally different use than what would typically be considered as home industry, but it's no different. It's a commercial use. It's the property owner that will be there on site regulating it, looking after it, and ensuring that everything else is complied with. The other thing I didn't mention that shows up on the site plan is they're also willing to plant a number of trees both across the front of the property and down the sides to also provide visual buffering of the use. Basically the same way that everyone up and down the street has trees in the front yard to provide a little bit of privacy. They're planning to go a little bit further and create, a complete visual barriers with the trees that they would plant. Yes, I know it's going to take a few years for those to grow up, but planning is long-term, and that's what we're looking to accomplish with it. So I hope that's answered some of the concerns and some of the questions. And thank you for your time and the opportunity to present.
Thank you, Paul.
You're welcome.
Is there anything else from the public that can be added?
Excuse me, Paul, are you reducing the building to 1,500 square feet?
No, we're still asking for the 2,000 square foot building. What we were showing was that there's really no impact, visual impact from the street. The other alternative for Charles and Jeanette You're allowed 3 accessory structures on a property. So there's storage rooms for the equipment that they need for the karate club. It just makes more sense to have them under one roof.
But you have lowered the height
We have lowered the height and
to the
we've
seven point
reduced,
five?
we're well below the 7.5. And we've reduced the pitch of the roof. It used to be a much steeper pitch, which increased the height as well. That accounted for about half of the reduction. And then with taking a foot out of the karate studio, we were able to come well underneath the maximum height required.
So why are we here then?
Well,
No, seriously, seriously, why are we here? Like, I mean, we're all RR, we can build a 1,500, a house, we can build a 1,500-foot, 30 by 30, 50 building.
mhm.
And all these kids can play, and with the long sticks or whatever, 12-foot ceilings, there's no problem there, right?
Absolutely.
So why does he need 2 apartments on top?
He's got 2 daughters. That's why it's.
They're never gonna get married, they're never gonna move out, or what?
And that's
No,
quite.
seriously, I mean, come on.
Well, okay, and no, you raise a very.
Like, I mean,
You raise a very good point.
It's,
So-
to me,
so let
to me, it
address
seems like, it sounds like it's a personal financial gain for Mr. Coutu to have those apartments. Like, he can already build a karate club.
Yeah.
He can build a house, he can build a karate club, he can build everything.
that. And he can put one
So-
accessory dwelling
So,
unit.
so why are we here? So that's the point, you know what I mean?
We are here and so, no, you
It's
raise.
a personal financial gain for him. It's not for the kids anymore. Because the kids already got the place.
Yeah, yes, it's a business, that's the point. But you raise a very good point. One accessory dwelling unit is permitted
Okay.
in the structure by precedent, and, the application just before us, it's also permitted as a standalone unit or in an accessory structure. The provincial legislation does not prohibit 2 or more, or 3 or 4 or 5 accessory dwelling units on a site. All it says is that you have to be able to justify putting those additional units on that particular site. Because you can see the existing homes that are in the area are on smaller lots. Would those smaller lots, accommodate 2 or 3 extra additional dwelling units? Probably not. And that's the reason the bylaw is written to permit 1 in the structure, but there's nothing in the provincial legislation that prevents the municipality from approving additional dwelling units if the site permits it. And that was the whole point of showing the relative size of this lot relative to all of the other properties in the local neighborhood. So,
Okay. Mr. But no,
Say,
as usual.
Okay, sorry, really, if you should be addressing the committee.
Okay,
and like,
sorry.
Just as a point of procedure, the question should be going through the chair and then the chair would direct them to the consultant. It shouldn't be a debate between the consultant and yourself. So I just, as a point of procedure, I ask you to direct the questions towards the committee and,
Ron,
Go ahead.
Trudeau, 733 Nipissing Street. So it's going to create added stress on the water table, having the 2 extra apartments here. Shower, laundry, and everything else. We barely got enough water down on our end of the street to keep 1 household home. It's going to create a major problem. It's going to drain the water table. Is the council and this valley willing to bring the water down to us if we run out of water? For free? Seriously,
That's not,
that's the thing, like,
I understand your point. Go
and
ahead.
through you, Mr. Chair, as we stated, that is the reason we hired one of the top hydrogeological experts in Northern Ontario, or in Ontario for that matter, Dr. Sig Kirchhofer, to address that particular concern. So we've heard the concerns of the neighborhood.
Yeah.
We're not going to move forward. A building permit will not be issued until we can prove that there is no impact on your wells. That is the point of the hydro-G assessment. Dr. Sig is very highly regarded. The municipality has accepted his work in the past on other sites. And he's been he's not a hired gun that just decides it the way we tell him to. He's come on many other projects here in the municipality where he simply hasn't been able to support the level of septics and wells in an area, and he's recommended either piped water systems or whatever. So he's very well respected. He's very honorable. That's why we brought him. So if anyone had specific concerns, he would be able to answer their questions. There were no concerns raised that night, so we didn't invite him back because we didn't think it was really an issue that needed to be addressed, and we're only addressing new issues.
That's right. Thank you.
So if it goes ahead, you're going to create a precedent, and this good council here, committee here will have a hard time denying the next guy that wants to open another business, another commercial or something. You know what I mean? It's not fair for them either. It's not fair for the rest of us. This is a residential rural area. Are you going to turn our street, our residential street into a commercial area? This is the problem.
Thank you. Go ahead.
Mr. Chair, just to a point to bring up about the lack of water or the water table. After reading the report, from what I understand, it's not a lack of water. It's a difficulty of extracting the water out of that silt, from what I can understand. So I'm no expert, but after reading that report, I don't think it would affect the water table at all. It would actually, it's actually the procedure to extract the water out of your water table that is difficult in the area that you're at because of that hard silt that's on that site. So in my mind, adding another complex or another house, just like you have houses on your side of the street as president, on the other side it used to be a farm. But now by putting a house and a business or a business from a house, I don't see that it's going to burden the water table. But again, that's just from what I can understand.
Through you, Mr. Chair.
Thank you, Councilor.
And through you, Mr. Chair, with respect to what the committee member Dan has stated, from talking with Dr. Kirchhoff, myself, that was his impression as well. It's a water retention issue. So anything that is used on site, any water that is drawn out, he will design a system where we ensure that it enters back into the groundwater. We can do that through infiltration chambers, other, French drains, whatever you want to call them, around the perimeter of the property. There's ways and means of accomplishing that. And that's exactly his approach to this particular issue. Now that's subject to further study, but that was his initial reaction also.
Thank you.
Paul Healy, 725 Nipissing Street.
Go ahead.
Just to mention to you, Paul, that you mentioned too that how the committee never mentioned anything about your curfew buddy, and you said that nobody in the community mentioned anything about your curfew buddy. When you stand up,
Who, sorry?
when you stand up and you tell us that my good friend is here to represent, then right away, it puts a backbone to us saying, why should we even ask about it? That's why there was no questions asked.
Well, he is a good friend of mine, and he's a colleague I've worked with.
Exactly, and this is where this is going. This is where I'm saying this. When you can stand up and say that he's going to get this passed for me, because now he is my good buddy,
I'm not.
it's not correct.
That
Sure,
is
that's
not,
irrelevant
that is
to
not
it.
what I've said at all.
It's irrelevant to it.
Go back to the minutes, you will see that.
I'm sorry. Anybody else has a question? Mark? No? Rock?
I'd just like to.
Go ahead.
The one issue that I have in the presentation that's been given is that the use that is proposed on this structure is permitted by the current zoning bylaws. And my interpretation of it is different than that of the consultant. I think that this is clearly a commercial use as opposed to a home industry or a home occupation. Home industry and home occupation are both clearly defined in the zoning bylaw. Additionally, on page 66 of the zoning bylaw that shows the uses permitted in commercial zones, it states recreational establishment permitted in C1, C2, C3. Home industry is home industry. There is a clear definition that it is a small industry. And the uses that are defined under industrial use in the zoning bylaw are very different than those that are defined under the commercial uses. And where I have an issue with it overall on a larger perspective is that we have commercial zones in this municipality. And some of those commercial zones fall within our downtown. We're very fortunate that we still have a thriving downtown, that we aren't faced with the empty storefronts and empty shop fronts that a lot of smaller municipalities in Northern Ontario are. And if we do set a precedent of allowing uses that are clearly defined as commercial within the zoning bylaw on residential properties, we are opening the door for an exodus of businesses from our downtown core and our existing commercial sectors, and there could be an impact on the community that is very, very far-reaching. And I do not agree with this statement made by the consultant, nor what was in the initial planning report, that this use, the use that's being applied for is consistent with the zoning bylaw. Thank you.
Okay. Anything new?
All home industrial uses are commercial in nature. They're not being done for the good of the people or just because it's a hobby. They're being done to be marketed and sold, or a product or a service being delivered. Every single one of them is commercial in nature. If you're looking after, old cars or redoing body work on cars, that's taking work away from the established businesses in the downtown core. All home industry, all home occupation is commercial in nature.
Thank you. Go ahead, Kathleen.
As a point, motor vehicle repair is not permitted in residential zones in our municipality. That aside, there is also a separate area in the zoning bylaw that outlines industrial uses and what industrial uses are and what commercial uses are. And so when home industry is mentioned, it does say an industrial use, and this is not an industrial use. Thank you.
Well, industrial and residential uses typically are not compatible, period. I think you're taking a very literal interpretation of the word industry as opposed to being work.
Thank you. Well, yeah, I understand. Okay. If there's nothing new, I gotta call it to a vote. Anybody in favor? It's defeated.
Yeah. Good job.
All right. We're done with this application. So I will recuse myself for the third one. And first and second, if you want to leave, you're most welcome to.
Kim, shut up.
Dan. You've got the
Rocks and red on the
you've got the honors.
Thank you, Mr. Chair. So, okay. Ça va? Ah oui, oui. The items and you read the resolution. Yes. Yeah, we will. Okay, so we'll move on to item 5.3, which is ZBLA 2025-3-2569 Ontario Inc., Dover Court Road, Springer Township.
It is moved by Kathleen Marchand and seconded by Roland Larrabee, whereas the public meeting was held on April 8th, 2025 and May 13th, 2025 for the purpose of amending zoning bylaw 2014-45, and whereas written concerns or objections have been received to the proposed amendment and have been provided to the Planning Advisory Committee for consideration, be it resolved that the Planning Advisory Committee for the Municipality of West Nipissing recommends that the Council for the West Nipissing Municipality adopts the proposed zoning bylaw to rezone the properties at Dover Court Road and is more particularly shown in the attached Schedule SF2 of bylaw 2014-45 shall be amended by changing the zoning designation of the properties, which properties are more particularly described as lots 4 to 6, block 21, plan 35, part lot 17, part 1, 36R-13244, lots 18 to 22, 36M670, Springer Township, Municipality of West Nipissing, from a residential 2 and residential 3 to a residential 4 zone to allow for the construction of a 26-unit apartment complex. Through you, Mr. Chair, this application was initially brought to the committee last meeting, and it has been referred back at the direction of the CAO. I can just bring the plan up here quickly. It was available last time as well. If my computer will respond to me, and I'll leave it with you.
Okay, thank you very
Thank
much. So when we had the last meeting for the planning, we were kind of short on time. So when we was also mentioned by Monsieur St. Louis, which was sharing that the public could ask for delegation. That's not the process. The decision made at the planning table here, and then our recommendation is put up to the council. So if any new information or people that didn't have time to finish to voice their opinions or any new item, this would be the time for you guys to speak up. And as mentioned, just as a refresher, we talked about the turtles, the bogs den, the driveways, the sewers, and the traffic in that area. So that has all been discussed. So if there would be any new information that somebody would like to add, I will open up to the public to speak. Please state your name and address, please. Go ahead.
Good evening. Do you want me to stand here or here?
So where do you want?
Okay, perfect. Good evening, committee. I am Christine Nickel with Thomas Davis Law, 690 McEwen Ave in North Bay. So just wanted to add some additional requests and considerations to the last meeting. Obviously, the primary objections center around two critical issues. The first being the risk of damage to surrounding homes due to the blasting of the granite outcroppings that are close to the neighboring properties, as well as the depreciation of property values. So first of the concerns we'd like to have addressed would be whether the developer and committee would agree to establish a damage contingency fund whereby the developer would have a separate account held for any damage done to the property, sort of as a safety net, instead of having the individuals have to go through their insurance, which can of course take a lot of time, to have something set aside that would be determined based on an independent engineering assessment of the blasting risk compared to the value of the nearby properties. And this would help expedite the repair of any damage to the homeowners to ensure that they're not displaced from the blasting. The second consideration would be having the developer do a pre and post inspection of the properties that are close to the blasting areas to inspect, the foundation, windows, things like that. Of course, we've recommended clients to take pictures of the properties and videos as well. The third kind of thing, of course, would be the blasting mitigation measures, of course, just ensuring that they follow strict blasting protocols and to advise the residents of any blasting given the close proximity to where the blasting is to their homes. The traffic and noise management plan that we would like to have in place, could include things such as limiting heavy truck traffic during school hours, maintaining clear roads from dust and debris, and enforcing noise controls in the area. Further, reducing the speed limit if there is going to be higher traffic due to the new R4 zoning. Another request and consideration would be in terms of land use compatibility. So as you may know, the official plan requires that new residential developments, including the R4 zoning properties, be compatible with surrounding uses. The R4 zoning for multi-unit buildings could disrupt the neighborhood character, increase noise, or reduce privacy due to the taller structures and higher traffic. Further, the Provincial Planning Statement 2024 promotes land use compatibility to avoid adverse impacts on existing communities. The R4 development may generate shadowing, traffic congestion, or parking issues, particularly if located in areas not designed for high-density residential use. As such, we would request, certain transitions such as buffering, sidewalks, etc., near low-density residential areas such as this. Another consideration would be to offset the potential impacts on property values. We suggest the developer could contribute to community enhancements such as community benefit charges like park upgrades, tree planting, pedestrian pathways that would help maintain or even increase the desirability of the area and put some safety concerns at ease. I know you mentioned last time they talked about entrance ways, but just moving the location of the parking lot so that it's not a nuisance to the abutting property owners across the street. The other proposal, which is something new that was discussed, is possibly having the developer move the development location to another suitable development lot and do sort of a land swap with the municipality and the developer that wouldn't require any blasting, be close to any neighboring properties, as there is some vacant land near the development site that could be considered as a building location for this type of complex. And of course, there is the restrictive covenants and subdivision agreement that's registered on title to these properties that we would just ask be complied with. So for example, the restrictive covenants say, the homeowner is only to build a single home. I don't know exactly the definition, but would a 26 unit, apartment complex constitute a home, as well as the removal of aggregate and fill under section 11 of the restrictive covenants on this property. So while we understand, of course, the need for development and increased housing options, we just ask the committee to prioritize protection of the existing residents and their concerns. The risk of blasting and property depreciation are, of course, real, and without proper safeguards such as those that we have mentioned, could leave homeowners bearing the cost of someone else's project. So we just, ask you to take into consideration all of those points to protect community cohesion in accordance with the Planning Act and the Provincial Planning Policy Statement, and in order to support community well-being. Thank you.
Thank you. Any questions by any public members?
Can I reserve my right to speak a little bit later, please? After I hear the committee's comments?
Yep. Go ahead, Paul.
Just a couple of quick points. The blasting industry is a very heavily regulated industry. I was involved with it myself many years ago. Blasting happens in urban areas all the time. We wouldn't have Sudbury if it wasn't for blasting in an urban area. There are ways and means. The blasts are specially designed. They use special low expansion explosives when they're close to a critical use such as a residence in nearby proximity. It is standard operating procedure for blasting companies to do a pre-blast survey. So they will send people around. They will meet with the property owners. They do. I've been involved in them myself. We do take pictures of the foundations. It's to protect both the property owner and to assist if there is an insurance claim, then those documented photographs are used to validate the claim, but it also protects the blasting company themselves too, because you will be amazed. And I know you've got fairly new homes, but we were involved with ones where there were clearly cracks in the foundation long before we got there, and then all of a sudden it was the cause of the blasting that caused it. Traffic within the subdivision itself, we don't see that this is going to increase any traffic in the subdivision. We're right at the corner. People will turn off Cache Bay Road, turn into the parking lot. That's it. There will not be any heavy truck use further into the subdivision other than to enter into this site, and the heavy truck traffic will only be there during the construction times. These units are being marketed towards seniors, most with a single vehicle. Oh, excuse me, I'm talking way too much tonight. And we meet the parking requirement. So we, the statement is we're going to be parking all over the road. No, we've got a parking lot design that meets the requirement, meets the accessibility requirements for barrier-free spaces. We've covered off all of that. Loss of property values, I don't think there's been a study yet that I've seen that supports that, putting a multi-residential or a higher density form of residential development impacts negatively the property values of those around it. In fact, there are numerous studies that have shown that the higher the density of a neighborhood, the higher the property values actually are. Land use compatibility. So the same builder that's building this built many of these people's homes, and he's going to design it to fit into the neighborhood. He's got very similar designs. It's going to look like the homes in the neighborhood. Yes, it's a different type of structure, but when you see the architectural designs, it will very much mirror what's already been built. He built them. So, and he also wants to live in this neighborhood in the future. The rental units are all going and this isn't, I said this at the last meeting, $1,500 to $2,000 a month for these apartment units. These are not low-end units. These are all fairly high-end, mid to high-end units that will fit in very nicely with the people that are in this neighborhood. It is being geared towards seniors. The alternatives. So we talked about the restrictive covenant. So there's some concern as to whether that's actually applicable legislation. There's two schools of thought on that also. But many of the neighborhood live in duplexes that do not comply with a strict interpretation of that restrictive covenant. So many of the people that are here are also the beneficiaries of the restrictive covenant not being followed to a very strict interpretation. So those are just some of my responses. The only other concern was that there would be overshadowing from the height of the building. Well, the bedrock is being brought down to a more level area, and it's only a one-story structure. As I said, this is being geared towards seniors, so there will be no steps. There is no second story. This is a low rise. In fact, like I said, this will fit very nicely with the character of the neighborhood. There will not be any overshadowing. If a strict interpretation of the restrictive covenant bylaw was followed, we have 5 subdivision lots that are affected by the restrictive covenant. Block 21 on Register Plan 35 is not encumbered with the restrictive covenant. So I did a few little sketches myself. Each of the 5 subdivision lots are of sufficient frontage and size. They can be further subdivided into semi-lots. As a matter of right, under the Planning Act, every single semi-lot also qualifies for 2 ADUs, so that instead of a single family home, you can have a semi, but 3 on each side. So on each of those 5 lots, you have a potential of 6 users, 30 units. Plus we can put a further 10-unit apartment building down on the Block 21 section. So potentially on this site, we could increase the density to 40 units and meet all of the requirements. We're proposing a 26-unit apartment building, much needed seniors housing that will fit very nicely with this neighborhood. It's being architecturally designed The blasting issue is being looked after. Qualified personnel will be selected to do the blasting. And the blasters have the insurance. That is the fund that you're talking about is the insurance fund. So hopefully that's clarified some of the issues, and thanks for the opportunity.
Okay, thank you, Paul. Ms. McNichol, did that clarify a few of your questions?
Yes, to a certain extent it did.
Okay.
Yeah, of course, we'd want to know the amount of insurance and, how readily available that would be if there's no separate sort of contingency or trust, held aside for the homeowners. I think it's good to know. I assume that the proper, mitigation would be used for blasting and all the proper, legal requirements, et cetera, as mentioned. Yeah, I guess the restrictive covenant topic, going back to that, obviously it exists. It's there. I understand there are some duplexes, I guess, but should we continue to, go against the restrictive covenants that are there for a reason would only be my other comments.
Okay.
Thank you.
Perfect, thank you. Any other questions from the public? Monsieur Gauthier, please.
I guess my biggest concern about all this is that really the blasting activity. There are two houses specifically, one at was Monsieur Lafont and Jean-Pierre as well, Bastien. Both their houses are securely fixed to the current rock outcropping that they are planning to blast. And I don't care who expert is going to be talking here, okay? With all due respect to yourself. When you go to blast something, percussion waves go through the rock and they're going to dislodge and they're going to damage existing homes where people have built and they've enjoyed the prosperity of that neighborhood. So I can't emphasize enough that this issue of potential damage to current existing structures at the benefit of a development that could be moved across the street where we would not have no blasting whatsoever. So a simple land swap deal between the municipality and the current landowner, where he could build 26, 40, 80, we don't care. We just don't want our houses to be damaged by an activity that I don't care how well you plan it, could damage our structures, okay? So please be reasonable about how you're going to develop this town in the fact that we all have spent a significant amount of money, and most of us, it's our largest investment, and you're planning an activity that could damage that. So please take that into consideration, and please do not move forward with any blasting. In our view, if we could do a land swap deal, you could make that a green space and therefore remove that green space from the other side of the road and then have a balanced approach where now you have an area where you don't have to do any blasting, you don't have to do any development, and the developer will be able to have his 26 unit, 40 unit. There's already a 43 unit complex slated for that side of the property. So why couldn't it be further moved so that that section now becomes a part of the community? It's reasonable that we would expect to be protected by a decision that this committee would make. To have insurance as a backstop is ridiculous. Who hasn't gone through an insurance claim where it's taken years to get their houses repaired once something has happened? And I don't care how good the insurance company is. If they don't want to pay out, they won't pay out, and then who's going to be left holding the bag? The homeowners, who have expressly today told you we're very concerned and we don't want this blasting to occur. It's beyond me that we're actually considering this, okay? And on top of that, we're saying that we're going to rent it to seniors that are going to be able to pay $1,500 to $2,000 to $2,500 a month. Really? How many people in this town just got evicted from their houses because they're paying $700 to $900 a month? There's 43 units that were closed. And now we're going to be saying we're going to be building another 26 that are even higher rent when we have a housing crisis right now. So to me, that smells very, very much that They may charge the $1,500 or $2,000 or $2,500 per rent, but it'll be subsidized by the Ontario government to make sure that those rents can go to people that can afford them, which falls under the definition of low-income housing, which you've stated at the last meeting would not be the case. So really, let's get real and let's make sure that we're going to make the right decision for this town and for our community. We have landowners to the right of the property who have been told, if they saw the stakes in their property, that they were going to be losing part of their property and the surveyor didn't do their job properly. Okay. How many other things are actually being done according to plan? How many things are not going right? And you're going to be subjecting our community to a potential disaster. And an insurance fund doesn't cut it. I would be really, really, really surprised if the developer would come up and say, okay, you know what? We need $200,000 a house for every house that is in the area of the blast area that he's got to put into a bank, put into trust, so he can't manage it and an insurance company can't manage it. And then say, okay, well, you guys went ahead with it, you blasted, but you damaged 5 foundations. That's $1 million out of his pocket. Okay. That is the type of decision-making that would make our community feel a lot more comfortable than what you're proposing of saying, well, the blasting company has insurance coverage. It's real easy for a company to change its name and avoid all that disaster after the fact. So please, again, we have a lot at risk with this blasting activity and the site preparation, when we have a very good option just across the street, which makes the developer build his building easier. No blasting, he can still put the building that he wants, and we still get the green space that should be across the street as part of the plan. So you just do a simple land swap, everything that's in the community right now that's creating stress and frustration disappears. So please consider that.
Thank you, Monsieur Gauthier. Any other comments from the public? Okay, I'll move it on to the committee now. So
Good evening, committee. Sorry, I'm here by video. Sorry, can you hear me?
Yeah. Name and address, please.
Yes, my name's Lucas Adonik. I am a lawyer representing Miss Andre Duquette. We submitted a letter along with Miss Nickel. I just wanted to add on some of the very apropos points that were already brought up tonight. Number one is on the subject of blasting. Yes, to dovetail with the previous comments, there was points made about the cost feasibility of the R4 development that's necessary to make the project itself cost feasible. One would think that drilling and blasting would create significant cost increase. So the viability of a land swap would look that much better in comparison. In my letter, I addressed the garbage and the recycling increase that would result from this construction. I'm not sure if that's been addressed, but I thought I'd raise that again. One of the issues that my client has been has noticed almost immediately is there used to be a 3-way intersection at Dover Court and Nico Crescent, and that's now disappeared. And there's been a frequent increase in traffic and a corresponding reduction in safety in that area. On the point of there won't be any increase in traffic or in residents. If it is going to be geared towards seniors, one would anticipate an increase in the caregivers for those seniors, which you would think would be a follow-on effect of that and create a significant increase in congestion in the area. And I believe those are all the points I wanted to add. Thank you for your consideration.
Okay, thank you. Any other questions of public? No? Okay, go ahead.
Hey, I'm sorry, I didn't catch your name, Mr. Lawyer on Zoom.
Sorry, it's Lucas Sadonik.
Hi, Mr. Zadonik. I just have one question. Your client, is that the house that's on the corner of Nico and Dorba Court, or is it a vacant lot that she owns at Nico Crescent?
It is a vacant lot.
Okay, so I just want to address the three-way stop. There are actually no structures on Nico Crescent. So that's why the stop was removed, is that there is actually no through traffic. There's no real street that exists, and there are no residences that have been built on that street. So, there's no increase in traffic because there was never any traffic going down that road except for the driveway access. Thank you.
Thank you. Thank you.
Can I comment?
No,
Absolutely.
No.
On that, that's a separate issue.
Yeah.
That's a separate issue.
No,
That
there's no
stop sign
comments.
is-
No, you've had your chance to speak. Now it's the committee's going to speak and then we'll decide on the matter, okay? You've had your chance to ask the question, okay? So I'll open up to the committee for any additional questions or clarifications. Any questions?
I have a question for the.
Go ahead, Kathleen.
If the lots were not merged and then developed as R4, the developer would still have a right to develop those properties and would be able to blast without going through any process of the planning committee. It would just be permits issued through our building department. Is that correct?
Yes, through Mr. Chair, that is correct. If they were to build according to the R2 and R3 zoning regulations that are currently on the site, they would be permitted to blast without any kind of planning application.
Thank you.
Good. Any other questions by board? Monsieur Saint-Louis?
Thank you, Mr. Chair. Just out of curiosity, several people have mentioned a land swap with the municipality. What land are they referring to, if I can ask? I don't want to get into more discussion, but are they talking of the mill site, or is there somewhere else that they are referring to?
I had the
That was my question too.
Yeah.
I had the intent. I thought it was in regards to the mill site. Is that correct? Monsieur Trottier, you made the comment? Yeah, it was in regards to the mill site.
Okay, thank you. So to add to that, although I understand what they're saying, we as a municipality really can't do any land swap with a developer because that site currently is not even available to build on until all the proper what's the word I'm looking for?
Environmental assessment.
Exactly, are being done. And I don't know when that's going to happen, or we don't know when that's going to happen. So I don't think that would be fair to the developer to provide him a parcel of land that, who knows, maybe something will come around and he will not be able to develop. So I don't think the land swapping option, unfortunately, is an option. Thank you.
Thank you, Mr. Saint-Louis. Go ahead.
If I may, Mr. Chair, Mr. Barbo may also want to.
It wouldn't be in the purview of this committee to discuss the land swap. That would be actually a land issue separate from the planning.
Thank you.
Committee.
Well, it's actually just a comment. Those lots, basically, in order to transfer that into green space, it would require an awful lot of remediation work and actually a lot of fill to be brought in, because it's basically rock. As a kid growing up, our ancestors used to actually drop off pulp there. That was the mill yard. And there used to be a big trolley going over the road there that actually used to bring the pulp over into the mill. And 40 years later, here we are, and this was subdivided, and there's 6 lots. And to be able to do anything with those lots, there needs to be some site remediation. In other words, some aggregate work or end drilling and blasting. And it's done daily all around us. And I'm pretty darn confident that especially being so darn close to Sudbury and even North Bay, there's piles of rock, and there's tons of rock that have been moved to make actual reasonable sites. And in my mind, it actually would complete what used to be a mill yard, and it's actually now a housing subdivision of town, and it would create 20 plus units when we have a critical housing shortage. So that is my point that I share with the committee.
Thank you, Monsieur Seguin. Monsieur Larrabee?
Thank you, Mr. Chair. I also had concerns with blasting, but yet I worked on pipeline, line 4. So they had 3 pipelines in the ground. We were putting in the 4th, and those were live. And on a daily basis, they would blast around those live pipelines. So those professionals do know, but sometimes, excuse my language, screw up could happen, and I hear your concern. For the water, especially in Florida, it's concerning. But and another comment was made about the prices of the apartments, which yes, there is a crisis in the apartment. And the only way I think to get the prices down is to have competitive. The more apartment you have, the more the price will go down. If you only have a few, prices seems to go up. So to bring the prices down, you need to build more. Then people, there'll be more apartments than people to rent it, so they'll start dropping the prices down. That's the logic I use on that one.
Okay, thank you, Monsieur Larrabee.
Hey,
Any other questions or comments?
can I say something?
No, I'm sorry. I gave you a chance, the public, you had your question, so I'm sorry, okay? Any other questions by board? Mark, please go.
Yeah, my questions were, thank you, Mr. Chairman, were answered by the questions from Mr. St. Louis. I just wanted to state that I also agree with both perspectives of Mr. Larrabee and Mr. Seguin. It's a perfect opportunity to add more in basically an ideal situation for the community.
Okay, thank you, Mark. Any other questions by board members?
One more comment.
Please go ahead.
Thank you. And like the mayor asked the question, if it was a home being built, there would be drilling and blasting, and there would be no consultation whatsoever because it would fit that area. So if a home can be built, this unit should also be allowed to go ahead. And you would go through the same thing.
Any other questions from the planning committee? Hearing none. Unless there's new items from the public, I will give you one more chance for questions. New items only. New items.
Oui, je peux-tu parler en français?
Oui, on va fort.
C'est parce que ce monsieur-là disait que sa logique à lui, c'est de bâtir beaucoup plus d'appartements pour baisser le prix des appartements. Je crois pas que sa logique est bonne du tout. Quand tu regardes comment que ça coûte aujourd'hui bâtir des appartements, les gars qui font des appartements n'ont pas le choix des louer chers. Puis la seule manière qu'il va avoir des loyers pour les gens qui n'ont pas ces moyens-là, c'est quand que le gouvernement va embarquer là-dedans puis il va lui donner des bonus pour dire, bah, tu sais, on va payer la différence. Tu veux 1500 ton loyer, loue les 900 à du monde qui sont capables de payer rien que ça. Nous autres, on va payer la différence. Parce que votre logique, monsieur, là, d'en bâtir plus pour payer moins, on parle pas de la Société Schneider ici, là. Comprenez ce que je veux dire?
Je comprends bien.
Ça fait que ça se peut pas. C'est pas une bonne logique. Faudrait baisser le prix de l'inflation. On vient changer de gouvernement, espérons que ça va arriver.
OK, merci, monsieur. Autre question?
Oui.
Envoie fort.
Concernant le stop sign, pourquoi être enlevé stop sign, ça double court? On va te dire pourquoi. Parce qu'il y avait deux
Monsieur Lafont, c'est pas pertinent.
pertinent.
C'est pas pertinent pour la rencontre de ce soir, là. We're here to discuss in regards to the 26 units. We're not talking about the stop sign on the overcourt, okay?
Ça commence par là.
I'm sorry.
Hein?
Okay, so hearing there's no more questions, we'll put it to a vote. So all those in favor of the 26 units, please raise your hand. Pass. Thank you. We didn't get rushed to finish.
Yeah.
Yeah.
Yeah, you should come back. for both.
Come back, yeah.
I'll go.
Okay.
Oui, non, mais en fait, notre décision,
None? Ready to adjourn?
Yep. It is moved by Roland Larrabee and seconded by Dan Senge. Be it resolved that the West Nipissing Planning Advisory Committee meeting of May 13th be adjourned to June 10th, 2025.
Everybody in favor?